Yo, yo, what's going on, folks? How's everybody doing? Pigman, Bradley, Jasper, KP, Lion 1, The Awakened, Mr. Satan, Sweet Tea Audits. How you doing? Kelly, what's up? News Now, Lipsia. I hope I said that right. Hello. What's up, Florida Watchman? Lewis, Pete. All right, guys. Real Jingy, what's up, buddy? We'll give it a minute or two to get some people in here. I got some interesting stuff to go over today. I got some updates. I have this origin of what law is that. Everybody in the community always tells the officers, what law is that? So I did a little bit of research, and as far back as I've been able to trace it, comes to us from 1637. So we're going to get into that, and that's actually pretty interesting. But we got some other stuff too coming up. So I'll give it another 30 seconds or so, and then we'll get right in on it. Yeah, KP. The line was actually, how does the servant come to the master with lies? Hey, Yin Yang. What's up, Forrest? Yeah, I saw the, I want to say CH and Ty debacle there. Um, and this is what I tell people. What's up, Devilman, Indiana? You're the man, J. King. Guys, Devilman, Indiana's got a birthday coming up here in like 3 days. He's going to be 59 years old. The guy's he's getting up there. So everybody wish Devilman a happy birthday. What's up, Jim Busby? Steve from the UK, what's up? All right, guys. All right, we got about 100 people in here. We got 3 minutes into the stream, so let's go ahead and get started. Like the title of the stream says, it's we're going to discuss the origin of what law is that, okay? And it's only going to take a couple minutes, and we'll get on to some other stuff. What's up for public safety? Guys, ignore Devilman Indiana in there. He's lying. That guy doesn't really know me. But, all right, so the origin of the saying, what law is that? So, in my readings, I got a book here recently called Our Nation's Archive, The History of the United States in Documents by Braun and Crosby. This was put out in 1999. It's a big book. It's about 1,000 pages with the index. And it basically goes through some documents in American history. So obviously it's got, all the important ones, the Declaration, the articles, but it also has a lot of lesser known documents in our history, including the Mayflower Compact, letters between presidents, just different stuff. And one of the short readings that it has in here is the examination of Miss Ann Hutchinson. Okay. And it provides the court transcript. Now, Miss Ann Hutchinson had moved to Massachusetts in 1634. Okay, and then she was banished in 1637 from Massachusetts. She went to live in Rhode Island, and after Rhode Island, her and her family moved to New York, where she and all of her family, except for one member, were killed in an Indian raid. But what we're interested in here is the trial of Miss Ann Hutchinson in Massachusetts in 1637. And basically, Miss Hutchinson was on trial because she was having a weekly meeting in her home for other females that was religious in nature. Okay, and we all know Massachusetts was Puritan, and they were pretty strict on that stuff. They even hung some Quakers in 1660, I believe. Mary Dyers was one of them. But so they were pretty strict on their religion there in Massachusetts back then in the 1600s. You know, that's where we get the Salem witch trials and all the other stuff. But in 1637, Miss Hutchinson was brought up on charges that she was conspiring with these women or whatever to, you know, not obey the decrees of the local religion, the local pastor or whatever. So the interesting part comes in the testimony, and I'll read you a little bit of that. Okay, so here, let's see. I don't want to read all of it because it's long, but we'll start off with Hutchinson saying, "What law do they transgress?" And Winthrop, the governor of Massachusetts, I guess was the prosecuting attorney at the time, John Winthrop, and he says, "The law of God and of the state." And Hutchinson's replies, "In what particular?" "Why, in this among the rest, whereas the Lord doth say, Honor thy father and thy mother." Hutchinson's replies, "Aye, sir, in the Lord." Winthrop goes on to say, "This honor you have broken in giving countenance to them." And Hutchinson's replies, "In entertaining those, did I entertain them against any act? For there is the thing, or what God hath appointed." And Winthrop replied, "Why, the fifth commandment." And Hutchinson's replies, "I deny that, for he saith in the Lord." And Winthrop replied, "You have joined them in the faction." And Hutchinson replies, "In what faction have I joined with them?" Winthrop says, "In presenting the petition." So I guess there was some petition that was circulated that she was supposed to have a hand in. And Hutchinson replies, "Suppose I had set my hand to the petition. What then?" And Winthrop replies, "You saw that case tried before." And Hutchinson says, "But I had not my hand to the petition." And Winthrop replies, "You have counseled them." Hutchinson says, "Wherein?" Winthrop says, "Why, in entertaining them." And then Hutchinson replies, "What breach of law is that, sir?" So that is that I've been able to find the first recorded usage of somebody asking, what law is that, I guess you could say. So I thought that was interesting. Miss Anne Hutchinson, her trial of 1637. What breach of law is that, sir? So yeah, interesting stuff. Bill of Rights, the date was 1637. It was the trial of Anne Hutchinson in Massachusetts. All right, let me look through here. All right. All right, guys. So with that done and being said, we don't have to go back over that. Anybody that wants to can rewind the stream and listen to that. Or you can also go out and purchase the book as well. Again, that's Our Nation's Archive, The History of the United States in Documents by Bruun, Bruun, and Crosby from Black Dog and Leviathan Publishers from 1999. A lot of good information in there, but you'll definitely be able to find the trial of Anne Hutchinson in there. All right, so moving along now, we are going to do a debate tomorrow night on this channel. It's going to be me against Legalized Drugs, aka Long Island Fraud. We're going to be discussing Constitution. We're going to be discussing law. So any of you interested in hearing me speak on those topics against Long Island Fraudit, who has gone haywire and I think smoked or shot too many of those drugs he was trying to get legalized, and he's gone off the deep end. But I get tired of these people running their mouths and not being able to back up anything. So I challenged them to a debate. I said, if you think you're smart enough, then I'm more than willing to take an hour and a half of my time and go through some stuff with them. So that'll be tomorrow night, 8 p.m. Eastern, here on this channel. We're going to do the debate with them. Now, also, I'm going to share my screen here because I got an update for the stupidest police chief ever video, which, as you guys know, was a couple weeks back, is in Alabama, Fayette, Alabama. So I do have an update there. Let me share the screen. Okay, I guess I'm going to have to share the entire screen. So let me do this. Okay, so now you can see this. So let me pop up this. Can everybody see this here? I don't think you guys can see, can you? Can you guys see that when I switch over to the when I switch over to the picture? Can you guys see that? Just type 1 if you could see that when I switched over. Because if you can, then I'll just go through the pictures. You can see the picture when I pop that up? Okay, thank you, Michelle. All right, so we'll go to the pictures. And this is an email that one of my subscribers, who was actually Hipaa trained, you'll read the email here, and he sent a letter to the Department of Health in Alabama to the lady who's in charge of privacy and Hipaa. So let's go ahead and we'll read through this real quickly. This is my subscriber, who is going to remain anonymous. Good afternoon. Thank you for responding quickly. This is in regards to the incident at the Fayette County Department of Public Health with respect to Hipaa and, more importantly, Hipaa training. This was published on social media, and I am bringing it to your attention, the misuse and misapplication of Hipaa. I retired after 45 years in the IT industry, working for health agencies, health insurance companies, medical billing agencies, third-party health administrators, and hospital networks. I am familiar with the rules and regulations as they have evolved with respect to Hipaa. One of my functions before retiring was to assist in the development of Hipaa training. My area of expertise was IT data security. The training was mandatory on a yearly basis for almost every employee at each agency, as well as the new hires during their first week with their employment. I also had to assess, all right, hang on. Hipaa breaches and submit analysis and loss prevention reports from an IT data security position. One of the employees at this location, in the presence of law enforcement, dropped Hipaa as the reason a citizen could not record in the publicly accessible lobby. Clearly, this employee used Hipaa as a buzzword that was then parroted by law enforcement. One would expect law enforcement to be ignorant of Hipaa. One should expect a person in the health industry to be properly trained. It is up to the Fayette County Department of Public Health to ensure all patients, patient information, and patient comfort are handled properly. If this gentleman had trespassed into an area where medical records are kept and acquired PHI, he would be arrested for trespassing and other applicable charges. What he would not be arrested for is a Hipaa violation. In such a case, FCDPH would have to report the Hipaa violation to the appropriate agencies, internal and external. This is not a criticism, and I've submitted similar emails to other healthcare providers where I was having a procedure completed. I just wanted to bring this to your attention. Over the course of my career, I had to report violations of employees who failed to apply this training in the course of their workday to our Hipaa compliance officer. Okay, and then anonymous. This email he got back from Pamela Kendrick from the ADPH, State Alabama, U.S. Thank you for the information, and I will reach out and provide additional training resources. Okay, Pam Kendrick, Privacy Officer, Office of the General Counsel, Alabama Department of Public Health. So, let me get this back. So, these people know what's going on. You know, they when we get in contact with the right people and they realize the correct way to go about things. Am I breaking up, Gray Dude? Can you hear me better now? Audio's going in and out badly. Let me know if that's any better, guys. I might have to get my other microphone. Is that better? It's probably this cord on this microphone. I got my headset on, so if it wiggles at all, it kind of gives it a breaking up type of deal. So this gentleman, a subscriber of mine, he reached out to the proper person, and we got results. Now we're going to have to go back there. We're going to have to do a revisit there. I've been trying to get in touch with the police chief. He won't return my calls. I'm kind of concerned that maybe our friendship wasn't as deep as I thought. So I'm going to have to go back there and re-cement those ties. Maybe bring a gift basket or something. And maybe we can build on that relationship that we started a couple weeks ago. Because I could tell he liked me. He was really digging my vibe. He he could really associate with me. So with that being said, okay, so we've gone over the origin of the what law is that. We've talked about the debate tomorrow night at 8 p.m. Eastern. If you guys want to see me discuss Constitution and law, we'll be discussing those against Long Island Fraudit, who is better known to the community as legalized drugs. Hello, No Justice, and Kimmy, how you guys doing? Good to see you. David. Yes, 100 likes makes the sound better and clearer. So the more likes that are smashed, the clearer my my voice comes through. Axiom's result. Let's put that question up on the stage here real quick. It's like I guess it's like a pre-debate warm-up, right? What do you think about the Amendment 14, Section 1, the first half? Are we supposed to be subject to the state, or is the state supposed to be subject to the people? Excellent question. Excellent question. Because there's misconception on what is the proper ladder of authority. All right. And the authority starts out in the state, as it does in the nation, as we the people. Okay. But we the people, as a political entity, has never been seen. It's never, ever been seen. No one's ever seen we the people. Okay. Because we the people would be every person at the same place at the same time. Okay. Just like, for example, the state. Okay. Because if you look at the legal definition of the state, the legal definition of the word the state is the people. Okay. So in a case from 1795, Penhallows versus Doane, the judge stated that if there were 10,000 people in the state and 9,999 of them showed up in one place at one time, it could not be said that the state was there for lack of the one person. Okay? So in law, technically, we the people is everybody in one place at one time. Now that's impossible. So the sovereignty passed down unto the elected representatives, our representative government. Okay, and that's where the sovereignty sits today. There's a famous case from back then, after the Revolutionary War, that said that the people of the states were kings unto themselves, and they had nobody to govern but themselves. And so basically, that's what we've done. We, the people, have set up a representative government to govern us individually. Okay? So the fact that we have a government means in and of itself that we are in fact governed. Okay? In order to be governed, you have to be able to punish those that don't listen. Okay? Otherwise, you're not being governed. It's simply anarchy. Okay? There's never been a nation of kings, of people that everybody could just do whatever they want and had to obey no law. There's never been that society, and there never will be. So, technically, we the people are above the government. But again, it's everybody in the place at the same time. Individually, we have to listen to what the government says, because that's the way the founders set up the government. Okay, it's called self governing. Okay, now the problem with that, as we all know and as we all see, is that the system of voting is dismal at best. Um, there's no way to verify the results. Okay, so basically, we're asking the government to watch over the government. Okay, because it's not who votes that counts, but who counts the votes that matters. Okay, because no matter what anybody says, we have to wait on the government to count the votes. So there's no checks and balances there. You know what I mean? Unless an individual goes across country to every person that voted and takes a poll. Okay, and then you'd have to rely on what that guy said. Okay, because let's say one guy goes around, he says, you know what, this isn't transparent. I'm going to go around, I'm going to poll each individual citizen. Okay, and let's say that one guy is a Biden supporter or a Trump supporter. As everybody knows, I'm not political. I'm not going to get political. This isn't about politics. Okay, this is about both sides. Okay, so but let's just say that this gentleman goes around to do this poll and he has a bias. Let's say he votes for Biden. He's a Biden guy. So he goes around and he takes his poll of everybody in America and he comes back and he says, oh, yeah, it's clear Biden won. You know, now everybody's got to trust that he's given us the correct numbers, even though he's got a clear bias for Biden. And the same way, if he was, a Trump supporter and come back and says, oh, well, it's clear Trump won, there's that lingering doubt. Okay. And it's hard for people to, I mean, a lot of people do, don't get me wrong. The majority of Americans trust the government. They trust voting. And they think that the guy with the most votes won, but I'm not of that opinion at all. Um, I've never been of that opinion. Law, Artie says, what even is law? And law is the right to govern. Law is the right of men to govern other men. That's always been what law is the right to govern other men, the right to prescribe punishments for laws being broken that the society has deemed to be against the law. Um, if you read Zane, um, he wrote a book in the early 1900s called The Story of Law. And in that book, he goes through the very beginnings, where law started, why it started, all the way up, I want to say, into the present age. But obviously, the book was written in the early 1900s, I believe 1906. But it's a great book to read if you want to comprehend how even law came about. It's called The Story of Law, and it's written by a law professor by the name of Zane. Artie says that sounds more like the definition of government than law, but government is law. I mean, there is no government without law, right? Just like there's no society without contract. There's no society without with obligations and rights. For every right there's an obligation, right? So and every society known to man, um, if anybody's into anthropology, there's a book called Man in the Primitive World, and it's written by a gentleman named Hobel. And it's an anthropology book, but he dedicates a whole chapter to what's known as status. Okay. And in every society known to man, he says, the members of the society have broken up the society into status. Okay. And obviously, in places like medieval England and stuff like that, you can get a clearer picture because you had kings, you had nobles, you had lords, you had dukes, you had serfs, you know what I mean? So you had all these classes broken up and defined. But even here today in the United States, we still use status. Um, and some of those status are taxpayer, resident, inhabitant, husband, father. Those are all statuses. Right, and Artie's right. That's a good definition. Let me put that up there, Artie. But and what I want to clarify is that even before a law is being able to be handed down and enforced by a governing authority, there has to be a law to create the government. Okay, and those are called organic laws or founding laws. Okay, and in the United States, our organic and founding laws documents are the Declaration of Independence, Articles of Confederation, Northwest Ordinance, and the Constitution. We have four organic laws that created and govern the United States. Um, and you could find those in the beginning of the U.S. Code in the title called Front Matter. Okay, they're all listed there. Um, so, okay, we gotten a little bit off topic of what I had originally started. Thanks Axiom's Revolt for getting me down a different path there. But the lone voice said, "Only law is God's law, and all others are bullshit." Now, people sometimes say God's law, sometimes people say natural law. I put a very, very informative video up on my community page by Mark Passio on natural law. It's different than natural rights, okay? But it's natural law, and I highly encourage anybody to go watch it. It's a 3-part series. Um, each part's about 2 hours each, but I guarantee you, you will be better and more well-rounded and more educated having listened to this 3-part series on natural law by Mark Passio. I can't stress it enough how important this video is in helping people understand some stuff. So if you get a chance, you're free this weekend. On my community page, you'll see it. It talks about natural law, Mark Passio. Definitely check it out. Give it a look. What have you got to lose, right? I also got that thesis put up in my community section. If I said, if you want to know where everything started from and what went wrong, here's a thesis to help. And that thesis goes over some misconceptions that a lot of Americans have about the founding, about our founders, and who it all benefited, and that kind of stuff. So really good information to go over. So we won't get into those right now. But what we will do is I'm going to share a screen. Ghostwriter, most of you guys know Ghostwriter. I haven't seen him in the chat today, but he's a regular subscriber, and he always sends me good information. The guy's a wealth of information, but he shared something with me, and I'm going to share it with you guys here right now. We're going to go over it. Let me pull it up on the tab. Okay, it says it's going to be sharing, so let me pull this up. I'll try to blow it up a little bit so everybody can see it a little bit better. Let me come back over here to StreamYard. Can everybody see that? Guys, if everybody can see that, type 1. Can anybody see that? Can you guys type a 1 in the chat for me? One. Okay, guys. Sorry, just popped through now. Okay, so let's go over that. I'll go back to that and we'll go over that. So this is a letter from the U.S. Department of Justice Civil Rights Division Special Litigation Section. Okay, from 2012. It's to the Baltimore Police Department, and it looks like who would be their representative, their legal counsel. Okay, it's about the Christopher Sharp versus Baltimore City Police Department case. Okay, the first part here just talks about a settlement conference, and it says, why we take no position on Mr. Sharp's claim for damages against the individual defendants. It is the United States position that any resolution to Mr. Sharp's claims for injunctive relief should include policy and training requirements that are consistent with the important First, Fourth, and 14th Amendment rights at stake when individuals record police officers in the public discharge of their duties. Thank you, baby. These rights, subject to narrowly defined restrictions, engender public confidence in our police departments, promote public access to information necessary to hold our governmental officers accountable, and ensure public and officer safety. So basically what we got here is a guidance letter that is directed to the Baltimore City Police Department because they arrested this gentleman. They seized and searched and deleted contents of his cell phone after he used it to record officers forcibly arresting his friend. All right. So in it, they go through a lot of stuff. It's 11 pages long. Okay. But there's some interesting stuff here that we want to touch on. It says policy should affirmatively set forth the contours of individuals' First Amendment right to observe and record police officers engaged in the public discharge of their duties. Recording governmental officers engaged in public duties is a form of speech through which private individuals may gather and disseminate information of public concern, including the conduct of law enforcement officers. All right, so First Amendment principles and case law establish that private individuals possess a constitutionally protected right to videotape police carrying out their duties. Okay, here's something important here. While courts have only recently begun to refine the contours of the right to record police officers, the justification for this right is firmly rooted in long-standing First Amendment principles. All right, I'm going to come back here to StreamYard for a minute, guys, because we're going to talk about the strongly rooted principles of the right to free press. All right, now you guys have heard me talk about it. 1774 Continental Congress letter to the inhabitants of Quebec, that the constitutional importance of the right to free press is to shame our public officials into doing what is noble. All right, it's to shame our public officials into doing what is noble. Also, Cooley's General Principles on Constitutional Law, pages 301, 302, right to free press, says again that it is the constitutional intent and importance of free press is to take and record, back then he was talking by, pen and paper, but by any means today, to record what our public officials do in the course of their duties and to report that back to the citizens so that the citizens may make informed, decisions on who these people are that are running their lives. Okay. A lot of times the press has been referred to as the fourth estate. Okay. And the reason it's been referred to as the fourth estate is because the founders envisioned the right to free press as a checks and balance on the whole government. Okay. You've got the legislator that keeps a check and balance on the Supreme Court, and you've got the Supreme Court that keeps a check and balance on the executive branch, and you've got the press outside of the government that is supposed to keep checks and balances on the government through their reporting of government activities. All right, that's why they've labeled it the fourth estate. Thanks, T-Dog. Roach Matt, why don't you contact me with that information? I'd like to find out that information, Roach Matt. So those are the founding principles of the right to free press. And when we look back at the time frame that the free press was included in the Bill of Rights and the political atmosphere and, what society had wanted of their government and, of these civil rights, this is, paramount to what it was invented for. The free press wasn't, and put into our liberties there for, keeping track of Kim Kardashian or of, sports or weather. All this stuff came later as far as that goes. But the importance of the right to free press was to watch over the government and make sure that they were guarding our liberties, guarding our rights the way they should be, and that they weren't taking money from the public till to enrich themselves and such as that. Because historically, that's what's happened throughout history and with governments. So it would be ignorant of us and ignorant of our founders to not create some kind of check and balance on the government, somebody to watch over them and report that to the citizens, who then could make informed decisions and get these guys out of office or instill a totally new government, like the Declaration of Independence says, if we find that this government is wanting. So all right, so let's go back here to the thing here. And it says the First Amendment has the right to gather information about government officials in a form that can be readily be disseminated to others, serves a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs. Okay, and the court said the application of this right to the conduct of law enforcement officers is critically important because officers are granted substantial discretion that may be used to deprive individuals of their liberties. That's from Gentile versus State Bar of Nevada, 501 U.S. 1030. Okay, it says public awareness and criticism have even greater importance, whereas here they concern allegations of police corruption. The extensive public scrutiny and criticism of police and other criminal justice system officials serves to guard against the miscarriage of justice. Okay. Nebraska Press Association versus Stewart, 427 U.S. 539, 1976, citing Shepard versus Maxwell, 384 U.S. 333, 1966. All right, let's go on. Courts have also extended First Amendment protection to recordings taken on private property, including an individual filming police activity from his or her home or other private property where an individual has a right to be present. Okay. Okay, it says Congress has enacted 42 U.S.C. 14141 in response to this incident. Section 14141 granted the U.S. Attorney General the right to seek declaratory or injunctive relief against law enforcement agencies engaged in a pattern or practice of violating the Constitution or federal law. First time I heard of this law was in reading this. I've already read this before, obviously. Ghostwriter sent it to me like last week. But the first time I read this is the first time I seen that law, so that's something to definitely look into, because we do have a few people that are, or a few agencies engaged in a pattern of violating the Constitution and federal rights. One that comes right off the top of my head was that video I did, Tyrants Go from 0 to 1,000 in Hoke County, North Carolina, where they said they had a policy that in order to come into the public lobby, you had to give up your Fourth Amendment right and show them ID. So that definitely, I think, will fit under that section there. Engaged in a pattern or practice. If they have a policy that makes officers violate someone's Fourth Amendment rights to be in a publicly accessible lobby, I think that definitely fits there, but we'll find out. See where I'm at. There was one here. Okay, it says other orders of General Order J16 also require further clarification. For example, General Order J16 states that officers may not prohibit a person's ability to observe, photograph, and or make a video recording of police activity that occurs in the public domain. General Order J16 at 1, but never defines this term. BDP should clarify that the right to record public officials is not limited to streets and sidewalks. Let me highlight that, okay? Because Long Island fraud it, and Artie, if you're still in here, this is something that he needs to understand. Maybe you can help explain it to him better. But the right to record public officials is not limited to streets and sidewalks, or what's known as traditionally public forum. Okay? It includes areas where individuals have a legal right to be present, including an individual's home or business and common areas of public and private facilities and buildings. Okay? Which is known as limited public forums. Okay? Now, again, this isn't me saying this. Okay? This is the United States Department of Justice Civil Rights Division Special Litigation Section. Okay, so these are the lawyers for the federal government that take on civil rights abuses that are saying this. So if these guys don't know, then nobody knows. Okay, this isn't, Artie, God bless his soul, who's a, defense attorney saying this. Okay, these are gentlemen and ladies that are specifically tasked with prosecuting and protecting civil rights for the federal government. Okay, this is like the top of the top. Okay, this isn't a phone call to the Department of Justice and you get the operator and the operator says, yeah, you're allowed to record in public areas. Okay, this isn't a lawyer for the Department of Justice who works in the bank robbery department. Okay, this is the Department of Justice, Civil Rights Division, Office of Special Litigation. Okay, these are the guys. These are the guys that are going to know what the law is. Okay, let's go over it one more time. It includes areas where individuals have a legal right to be present, including an individual's home or business, and common areas of public and private facilities and buildings. All right. Let's see. There's some other interesting stuff in here. The right to be heard before being condemned to suffer grievous loss of any kind is principle basic to our society. It also goes into the fact that nobody needs press credentials. There's a lot of really good stuff in here. We're not going to go over all of it because, like I said, it's 11 pages. We're on page 6. But there's a lot of good information available on this. What I'm going to do is I'm going to upload it to Mediafire, and then I will provide a download link in the description of this video. Okay, and here it talks about speech is not protected by the First Amendment if amounts to actual obstruction of a police officer's investigation. It gives examples. So, for example, if you're at a traffic stop and you're yelling to the person pulled over that they don't have to provide ID or they don't have to speak or something like that, that the court has decided is obstruction. Now, what you can do is you can sit there and say, you could say, well, the Constitution doesn't allow this or that or this or that, not directing it to the person that's actually pulled over, but you yourself voicing your displeasure with what the officer is doing. Now that's legal. All right. So you could stand there, you could yell F you could yell, you guys are, mofos. According to the Constitution, you can't ask for ID without probable cause. You can yell all that stuff, but what you can't do is you can't go, hey, dude, you don't have to answer any of his questions. Hey, dude, you don't have to provide your ID. Okay, that's obstruction and interference, according to the courts. All right, and that goes over that in this. So the best way to defend ourselves against what's going on while we're out there is to have an understanding of what constitute these actions. And there's no better place to get it than from the courts themselves. They'll tell you what's allowed and what's not allowed. You just got to do a little digging and find it. But I want to thank Ghostwriter who sent this to me. I had never seen it before. And I'll definitely be putting up the link so everybody can share it. They can look it over. Again, knowledge is only going to help us in this fight. And this is chock full of knowledge, again, given by the guys. All right. There's nobody that should know more about what we're doing and the legality of it than the guys that wrote this right here. All right. I know Long Island Fraud, it has this memo that he's putting out that he swears, blah, blah, blah. I read the memo. It's garbage. A lot of these guys in the watchdog community will talk about the public forum, the limited public forum, and try to associate the right to free press with that limited public forum, when a clear examination of the limited and the public forum doctrine, it shows only cases that deal with speech and protest. And in the few examples that they do have, one was where a gentleman was denied. He was a reporter. He was denied entry into a press conference. But what they fail to realize is that the press conference wasn't open to the general public. So if the press conference would have been open to the general public and they had denied this reporter, then that would have been a viable claim. The same thing with another case they recently found, which was Buta, in which case the gentleman was in a lecture hall and he had been recording and he had been asked to leave. Again, this lecture hall is not a place that was open to the public generally. Okay, so there was no claim there. Those are the only kind of cases that they have that they can bring up. Everything else they talk about, Adderley, protest, all these cases. I included a link in my community section for a legal review paper that goes over the history of the public forum doctrine. And you'll see every case that has to deal with public forum, every landmark case, Davis, Tinker, Adderley, they all deal with protest and speech. None of the landmark decisions for public forum doctrine deal with free press at all, and don't mention them at all in those cases. So yeah. So listen, guys, I'm going to let you go. It's been about an hour. We've covered a lot of the information I wanted to. I'll get that link for this in the description for you guys here by the end of the day. You'll be able to check that out and see what it's all about. I want to thank everybody again, of course, for coming. I haven't been out this week. Running low on some funds, so I haven't been able to go out, but hopefully we'll get out next week and get some more content going. Again, don't forget that we are doing the debate tomorrow night, 8 p.m. Eastern. So you guys will see it. So thank you guys, and everybody have a great day. All right.